Thanks for joining me in this video. Being denied entry to Canada can be a challenging and stressful experience. However, for those who face this situation, there are options available to appeal, seek re-entry, or even overcome the reasons for inadmissibility. Individuals may be denied entry for various reasons, including criminal history, medical inadmissibility, lack of proper documentation, or even misrepresentation. Understanding why you were denied entry and knowing your options can make a substantial difference in pursuing a future visit or a permanent move to Canada. The reasons for denial entry. When entering Canada, immigration officers review documentation, assess admissibility, and can deny entry if they find issues related to criminal inadmissibility. Having a criminal record, even for minor offenses, may prevent someone from entering Canada. Criminal inadmissibility is one of the most common reasons for entry into Canada, particularly for convictions like DUI, theft, or drug-related charges. Canada has strict laws regarding criminal records or even convictions from years ago, which can result in inadmissibility. Medical inadmissibility. Canada's immigration laws include provisions to deny entry if a person's health condition possesses a threat to the public safety and health, or is likely to cause excessive demand on our healthcare system. This can include contagious diseases or medical conditions require extensive and costly treatments. The third, which is the most common one, is misrepresentation. Providing false information, omitting details, or using fraudulent documents can lead to a finding of misrepresentation, which can bar an individual from entering Canada for up to 5 years. IRCC considers honesty a priority in immigration matters, and any detected inconsistencies may lead to serious consequences. Also, lack of proper documentation. Missing or incorrect documentation is another reason why individuals might be denied entry. This can include insufficient funds, invalid travel documents, incomplete visa information, or failure to meet the requirements of the visa type. For example, entering Canada on a tourist visa but expressing the intent to work can lead to a denial. Also, financial concerns. If a visitor is unable to prove they have sufficient funds to support their stay, an immigration officer may refuse their entry based on concerns they may have regarding overstay or seek unauthorized work in Canada. So what are some of the options available to you? If you've been denied entry to Canada, understanding your options can provide a path forward, whether for a short visit, work, or eventually permanent residency. So here are some common ways to address inadmissibility and apply to enter into Canada. The first one is called the Temporary Resident Permit, also known as the TRP. A TRP is a document issued by the Canadian government that allows inadmissible individuals to enter Canada on a temporary basis. TRPs can be granted for cases where the individual's reason for entry is considered justified despite their inadmissibility. So, for example, an individual with a criminal record who needs to visit family or attend an important event in Canada can apply for a TRP. TRP applications require applicants to demonstrate that their purpose for entering Canada outweighs the potential risk. For those granted a TRP, it is crucial to adhere strictly to the conditions, and any violation may affect future immigration applications. TRPs are discretionary, so it's beneficial to present a clear and compelling case for your intent to stay in Canada, emphasizing the limited nature of your visit and your commitment to following all Canadian laws. Another one is called the criminal rehabilitation. Individuals with a criminal record can apply for criminal rehabilitation to permanently resolve their criminal inadmissibility. Criminal rehabilitation is a one-time application that, if granted, means that the applicant is no longer considered inadmissible due to past criminal convictions. So how do you become eligible for a criminal rehabilitation? Criminal rehabilitation depends on the type of crime, the sentence served, and the amount of time that has passed since completing your sentence. Generally, 5 to 10 years have to elapse. Criminal rehabilitation is an ideal option for individuals with older convictions, and you want to establish a clear path visiting or moving to Canada without restrictions. The process requires detailed documentation, including your criminal background, proof of completion, your sentence, and evidence of rehabilitation, such as stable employment or community involvement. If criminal rehabilitation is granted, it offers a permanent solution, making it a favorable option for long-term entry planning. There's also something called deemed rehabilitation. Some individuals may qualify for this, meaning they are automatically considered rehabilitated after a certain period if they have only one minor conviction. For example, a person with a single DUI conviction over 10 years old might be eligible for deemed rehabilitation, depending on the specific circumstances and the similarity of the Canadian and foreign laws regarding the conviction. Deemed rehabilitation can occur automatically when enough time has passed since the sentence has been completed, provided no other criminal issues have risen. Also, something called authorization to return to Canada. For individuals who've been deported from Canada, an authorization to return to Canada is needed. ARCs are often required when a removal order has been issued, typically due to serious infractions like an overstay of a visa, failing to meet the conditions, or criminal conduct. An ARC application involves explaining the circumstances of the previous deportation and presenting compelling reasons for return, with proof that steps have been taken to avoid repeat previous mistakes. Also, some people are medically inadmissible to Canada. In cases of medical inadmissibility, certain individuals may apply for a medical waiver if they can demonstrate that their entry will not place excessive demand on Canada's healthcare system. Some medical conditions might initially disqualify someone from entry. However, providing a medical record and showing a willingness to take necessary precautions or cover personal healthcare costs can sometimes make a difference. Additionally, under the excessive demand exception, applicants with family members in Canada, such as their spouse or children, may still be eligible to immigrate if their family's needs justify the entry. If you have questions about the medical inadmissibility and how you can overcome it, do contact us because that can be a bit tricky. What about responding to a procedural fairness letter? In some cases, applicants may receive a procedural fairness letter, also known as the PFL, from IRCC if there are possible concerns about inadmissibility. A PFL provides an opportunity to respond to allegations, clarify any misunderstandings, and provide additional documents that may alleviate the officer's concern. This response period is crucial for applicants as it often the final chance to address any doubts before a decision is made. I will repeat that again. If you are issued a PFL, that ultimately means this is your final chance to prove your admissibility or overcome your inadmissibility one last time. After you have made your arguments and given it to the officer, there will be no other communication other than the final decision by the officer. In response, applicants should be transparent, provide relevant documentation, and ideally seek legal guidance if needed to ensure that their case is presented accurately. So just to summarize, a TRP is a temporary resident permit, meaning for temporary entry and to overcome your inadmissibility on a temporary basis. If you need to permanently take care of your inadmissibility, then we have to apply for criminal rehabilitation. An ARC, or an authorization to return to Canada, is if you've received a removal order from Canada, a deportation to be specific. Again, a PFL is issued in case an officer has concerns or questions with regards to certain inadmissibility, giving you one last opportunity to explain the situation to the officer. If you have any questions regarding this, feel free to give us a call today. Thanks so much, and until next time.